Welcome back to Live Free Legal. I'm Tiffany Lesnick, your domestic violence attorney, survivor of domestic violence, and advocate. Today, we're ending Family Court Awareness Month with one last powerhouse topic: coercive control, the number one form of abuse that influences custody decisions, but the thing courts can often misunderstand. If your ex seems charming in public but terrifying in private, if he twists the children against you, and if he uses the legal system to keep hurting you, you are not alone, and this episode will empower you. Many judges look for bruises, but coercive control leaves invisible injuries: hypervigilance, anxiety, fear, exhaustion, trauma in children, decision paralysis, shame, and confusion. Abusers many times may not appear aggressive in court, but sometimes they do. Many times they can appear calm, confident, and reasonable, and that's part of the strategy. You must learn to expose the pattern and show who they really are. And you must also learn how to control yourself so that you don't come across as overly emotional, anxious, reactive, exhausted. We want to be able to tell our story with confidence, with clarity. That's what the judges are looking for. Okay, we can learn these patterns and we can learn how to do this so that we can have very successful outcomes in order to win primary or sole custody of our children in custody court. Just because you are going up against an abuser in court for custody of your children does not mean that you are doomed. It does not mean you cannot have a successful outcome. I have been helping hundreds and hundreds of women have very successful outcomes in court against an abusive co-parent, and you can too. And so my goal through Live Free Legal is to teach you how to do that, right? So one of the very first things that I think is very important for all victims or survivors of domestic violence to do is learn how to get grounded and get calm. And the best way to do that is to surround yourself with a good support team. And many times that means a therapist. Getting into individual therapy, getting connected with a domestic violence organization, a domestic violence support group, getting into a small group with other like minded women, surrounding yourself with good family and friends. And I know when I was first coming out of a domestic violence relationship and someone told me you really need to be in therapy, I remember being so insulted by that. Because I was like, I'm not the one that has the problem, right? He's the one with the problem. He's the one with the problem behavior. But what I didn't realize at that time, coming out of that abusive relationship, is I was with him for 13 years. And in that 13 years, he kept telling me all kinds of things that weren't true, that I wasn't good enough, that I wasn't worthy, that I was stupid, that I wasn't a good mother, that everything was all my fault. Lie after lie after lie after lie, that over time I started convincing myself and believing. So I needed to go to an objective, neutral, professional person to help get this, what I call stinking thinking, out of my head, right? Reprogram, retrain me to be able to think correctly, objectively, neutrally, valuing myself again. That was so, so important to be able to become confident, to be able to be in control of my emotions so that when I had to go testify in court for custody of my children, I could do that in a way where the judge looked at me and I had credibility. Right. And they could trust that, hey, this is a mom who is going to be able to take care of her children. Right. She's peaceful. She's professional. She's polite. She can tell her story well. We don't have mental health concerns about her. Whereas dad would come into court and he would be kind of the polar opposite, because not all abusers, not all coercive controllers are charismatic in court. Some are, but not all are. Some come in and say the most inappropriate things because they violate social boundaries, right? And they do things that are socially inappropriate, and that tends to manifest itself in court as well. So here's some 10 real life examples of coercive control in custody cases. One, harassing communication. hundreds of emails, rapid fire texts over and over and over again, or inflammatory messages. Also threatening you. Pick up the phone. You better answer me. You better answer me now. Pick up, pick up. I need to hear from you. If I don't hear from you in the next 10 seconds, there's going to be fill in the blank. So harassing communication, financial strangulation, stopping support, overspending, hiding income, not paying the mortgage, not paying for insurance, taking you off the insurance, not making the car payment, maybe even not paying for the children's daycare or preschool or private school tuition. Number 3, medical sabotage, ignoring appointments, refusing medication, undermining doctors, maybe canceling the children's doctor's appointments, canceling their surgeries. What I will say for this one that is very important is that women get really, really upset when it comes to abusers interfering with the children's therapy, medical appointments, professional appointments, educational, which we're going to get to next. You need to let them authentically behave the way they do, because you've got to build up your evidence to show who they truly are. If you come in and you save them, I know you're trying to save your children, but what you're technically doing is you're saving the abuser from their own behavior. They're not documenting anything in the record. You're not developing any witnesses at the school, at the medical appointments, the pediatrician or the therapist who's getting to see his genuine behavior for who it is, who will then come and testify against him later. You're not creating a sabotage where he's interfering with the children's ability to get mental health care or medical health care, thus undermining your ability to get sole legal custody later. So for the long-term goal, we have to let him be who he authentically is on a short-term basis so that we can protect our children long-term, right? Let him come in, let him act the fool, do what he's going to do so that we can build up that evidence that we need on a long-term basis. So number 4 is school interference. Showing up unannounced, pulling the children out of school, withdrawing the children from school, changing their schools, harassing the teachers, embarrassing the children at carpool, you name it. I'm sure I'm not listing all of the potential things he could be doing. Weaponizing scripture, twisting faith to justify control, twisting scripture so that you have to comply with everything he tells you to do, and you have to comply with his sinful behavior. He's not using it for righteous purposes. He's using it for power and control over you in order to manipulate you so he can do whatever he wants to do. And that is absolutely not godly. So number 6, guardian ad litem or PC manipulation. Using charm, tears, victim playing, involving those professionals to make you look like you're the one always causing the problem. The good dad show theatrics. So performative parenting only during pickups or court hearings. So when there's other people around or he knows the eye is on him, people are watching who are important, he is the perfect parent. He can hold it together for that short period of time. But then any other time when other people are not watching, he is just awful to deal with. Number 8, isolating the children from you, creating fear, guilt, or pressure that's going to harm your children, blaming you, telling the children it's your mother's fault that we separated or divorced. It's your mother's fault we had to sell the house. It's your mom's fault that your pet can't live in both homes, or whatever the case may be. Your mom's not smart enough. Your mom this, fill in the blank, causing your children to distance themselves from their relationship with you. Number 9, litigation abuse. Filing motions to drain you emotionally and financially, using attorneys to harass you, or maybe the opposite. I've also seen abusers who who bury their head in the sand, right? They refuse to move forward. They're constantly asking for continuances. They don't produce documents like they're supposed to. They refuse to move. They refuse to do anything, and you can't get your case progressing forward. You are having to file motions to get them to produce the documentation they're required to do. And so that causes litigation abuse as well. So threats, number 10, threats disguised as concerns. If she doesn't cooperate, I'm going to have to ask for full custody, that kind of thing. I'm really concerned about the children and your parenting because you've been so emotional lately after he's just gone on a binge of insults and threats to you. Okay, these are all forms of coercive control. So, judges need patterns, timelines, concrete examples, and then they also need how it impacts your children. So we want to keep everything as child focused as we possibly can, right? We don't want to be focused on the abuser. We want our language to be centered around how did this affect my child? How are they experiencing the abuser's behavior from an emotional standpoint and a physical standpoint? Like, what are we observing with our senses? What do we see? What do we hear? What are our children saying? Are they crying? Are they having nightmares? Do they have tummy aches? Are they refusing to go to school? Are they having panic attacks? Are they not eating as much anymore? And then how is that impacting their behavior? Are their grades going down? Are they having to go to the doctor more frequently? Are we having problems with incontinence, potty problems? Do we then have records to back that up? Could we get medical records? Could we get educational records that we could come into court and say, ever since we've had this 50-50 schedule, or ever since he's had overnights or more time with the children, their behavior has started to dysregulate or go downhill? What documents do you have to support that? Have your timeline, show the pattern, show when this happened, then this happened to the children, right? You want to show a clear catalyst for the judge as to when your children started to become impacted and affected by his behavior. We also want to just be very factual. Tell the story. Learn how to tell your story well, rather than, again, being abuser focused, pointing your finger at him, calling him an abuser, calling it abuse, calling him a coercive controller, calling him a narcissist. We don't want to label things. We want to describe the behavior. We want to describe what happened, and we want to allow the judge to put labels on things. Okay, so we want to create a timeline. So important. List behaviors, his behaviors and the children's behaviors by date, category, and effect on the children. When I say category, I mean things like medical neglect, educational neglect, therapeutic neglect, abusive behavior. Whatever category you feel like is very important and is having an impact on your children, list that as a category. Maybe your children have a disability, they're on the spectrum, or they were born with a disability and he's neglecting those issues, refusing to allow them to wear their braces or get their speech therapy or interfering with those things. That would be one of your categories. So then we want to have number 2, screenshots with context. What does that mean? We've got to have certain things in our evidence in order for it to get admitted in court. So make sure when you take a screenshot of a text message or anything else that it includes timestamps. So it's got to have the date and the time on it, or it's not going to be admissible. And then we want to try to have full threads, not isolated text, not just his one little message to you, but we don't know what you said before or what you said after. We want to try to have the full text. And we also want to have identifying features as to who's communicating. So either his phone number and your phone number, or maybe his name and your name, so we know who's communicating. And this applies to email messages or any other form of written communication as well. We need a date. We need a full thread. You don't have to do the entire, we don't need 150 pages of messages. But if you're communicating, let's say on September 1st, let's have all the communications from September 1st. We don't want it cut off midway through a sentence. You may not be able to get those messages into evidence if half a sentence is missing. Okay. Write short summaries tying behavior to harm. That's going to help you be able to describe for the court, be able to tell your story. You're probably not going to be able to present that into evidence, But that's going to help you organize your own thoughts and help you to be able to articulate that later on when you have to talk about it. Judges respond strongly to statements like, this behavior increases the children's anxiety and affects their school performance. So, what is he doing, and how are the children responding to those behaviors? Okay. And again, I mentioned this earlier, use third party records. So, gather up records, guardian ad litem notes, school logs, school records, my chart, medical records from the children, therapeutic records, teacher reports or teacher notes, things of that nature, attendance logs, any other outside data or records that you can use to show the children or the abuse is having an impact on their behavior. We absolutely want to do that. And then you want to create a trial binder. So we want to create a binder, and this is my Live Free Legal binder, but it's, just like a school binder. And you are going to put all of your data in here. You're going to organize it by tab. And then you're just going to write on your tabs by category or theme so that you can put everything in this binder and keep it organized. Another way to organize your information is in like a shoebox or just a really pretty box. I think it's much better though to use a binder, and then you can even create a table of contents for yourself so you can keep track of, okay, tab 1 is legal custody issues, tab 2 is medical issues, tab 3 is therapeutic issues, tab 4 is educational issues, tab 5 is abuse, however you want to label it, but keep it together. That will help you if you're representing yourself, or if you have an attorney, it's going to help reduce your attorney's fee. Your communication is also evidence. So, as I've mentioned in multiple videos, right, you want to keep your communication brief, informative, factual, and friendly, or BIFF communication, or another way to describe it is yellow rock. Okay, so some examples are, I will follow the court order as written. Please confirm pickup at 4 p.m. Our child's teacher recommended fill in the blank. For the sake of the children, I will not engage in personal attacks. Want to keep the communications clear, child focused, and brief, because that's when the abuser gets bored. So short, neutral, documented. Judges want to see a parent who can demonstrate stability, safety, the ability to document appropriately. They want to see patterns of behavior to see that this is consistent, like this has been going on across time, so it's likely to continue. This is not just a limited one-time event, right? They want to see you having a calm demeanor, and they want to see facts over emotion. If you can't tell your story, if you're up on the stand crying so profusely, the judge can't even understand what you have to say, you're going to have a real hard time advocating for your children, right? It doesn't mean you can't cry. You absolutely can be emotional, and you should be emotional, but you can't cry nonstop. You've got to be able to tell your story. And you also have to be able to tell what the impact on your children is, what the abuse and his behavior, how that's impacting the children. Again, keep it child focused. Okay. Your job is to tell the story the right way: organized, neutral, chronological, child focused, calm, not overwhelmed, empowered. You have the ability to do this. You are their mother. You were specifically designed and chosen by God to be their mother. You have purpose, you have identity as their mother, and you have strength. Thank you for joining me today as we close out our Family Court Awareness Month. If you found this helpful, comment FCAM in the description, and I'll send you my guide, Top Lies Abusers Tell. You can download that guide in the description below. If you want more information or want to learn how to improve your legal outcomes in court, join our Empower Her annual membership. It's private and it's only $35 a year for weekly coaching and legal strategy. I also have legal coaching groups. They're 12-week coaching groups. Those will be starting up again in the winter. And that's $35 a week. So you get much more in depth, hands on training on how to be more successful in your legal cases. Share this video to help another woman find her voice. If you want to join one of the legal coaching groups or join Empower Her, click on the description and the links below at livefreelegal.com. Share this video to help another woman find her voice. Remember, you are not alone. You are not powerless. You are equipped. You are protected. And you are walking this battle with the God who sees, who fights, and who restores. Thank you. Can't wait to see you next time.